So welcome to the Regulatory Policy Seminar. I'm Joe Aldi, the faculty chair of the Regulatory Policy Program at the WaxmanMarquis Center for Business and Government here at the Harvard Kennedy School. We're thrilled to have you with us here today, and we are excited to have our colleague from Harvard Law School, Richard Lazarus. Professor Lazarus is the Howard and Katherine Aibel Professor of Law at Harvard University. He teaches environmental law, natural resources law, Supreme Court advocacy, and the torts. He has participated in representation of the United States, state, local governments, and environmental groups before the U.S. Supreme Court on 40 cases, and has had the pleasure of presenting oral argument in 14 of those cases.
Pleasure?
Pleasure. Professor Lazarus has recently published a book that came out this spring, The Rule of Five, that is a fantastic story. And I mean that as a story as one academic colleague to another. It's a great read, a fantastic story about the history of how we came about thinking about the regulation of greenhouse gases under the Clean Air Act, telling a story really over several decades, culminating with the Supreme Court ruling of 2007. Professor Lazarus is going to present to us here over the next half hour or so. He'll be using presentation slides here in a moment that he'll bring up. I ask you to have questions ready. You can use the Q&A tab at the bottom of the Zoom screen. I will be then curating the questions throughout once Professor Lazarus is done with his remarks. I would also like to remind you that we are recording this session and we will be posting it to the Regulatory Policy Seminar webpage. So if you have some friends or colleagues who couldn't join us live, I know some of us have friends who are all over the world at this time, please let them know that they're welcome to check this out online once we have it posted. We will end a couple minutes early today, about 12:55 Eastern Time, because Professor Lazarus has to run to another Zoom room to teach his class. So with that, let me now turn it over and say welcome, Richard. It's great to have you here in this seminar.
Great. Thanks, Joe. Let me just do my share screen, then I'll be with all of you in a moment. Making sure everyone can see that?
That looks good.
Great. We're in business then. Thanks, Joe. Really, this is fun. It's a pleasure to be over at the Kennedy School, at least in the Kennedy School Zoom room for this live streaming event hosted by the WaxmanMarquis Center for Business and Government. And I really want to give special thanks to Joe for inviting me to give this talk. So my talk is about my recently published book called The Rule of Five. You can see it behind me, Making Climate History at the U.S. Supreme Court. And I'm going to divide my talk into three parts, then followed by Q&A. First, I'll give you a sense of the arc of the story, my overall goal in writing the book. Second, I'm going to highlight parts of the book's story, provide you with a sense of the book's voice and what makes the story so engaging. And then I'm going to reserve some surprises. You have to buy the book to find out everything that's in it. And third, I want to address an unanticipated challenge I had as an author in writing this book, and then how I chose to address it. So let's begin with the story's arc and its primary objective. It's divided into 20 chapters, followed by an epilogue. It literally begins with a guy named Joe. I'm sorry, it's not Joe Aldi, but another wonderful Joe, a guy named Joe, and the story ends with the Supreme Court ruling that made history. The most important environmental law case ever decided by the United States Supreme Court. It's called Massachusetts versus EPA, often referred to as environmental law's Brown v. Board of Education. A case that not only transformed U.S. climate change law, but has had worldwide impact. So what are my primary goals in writing this book? First, to write a book for a popular audience that revealed what makes the Supreme Court advocacy so challenging, so fascinating, and from both sides of the lectern, where the advocate stands to argue before the justices, but then also the other side, within the court itself, the other side of the lectern, behind the red curtains. I want to open a window to let the general public see inside. The extraordinary amount of strategy, maneuvering, conflict, the personal and professional drama, and not from bad motives, but when the stakes are so high, and it's hard to get higher than you talk about climate change. I also want to write a book for general audiences that revealed what has made it so difficult for our country to address the climate change issue. Why it's proven so hard, often for reasons most don't know. and why, for that same reason, this case was so important. No more important environmental issue faced in the US and the world today than climate change. And as the coronavirus has underscored for all of us, there's no escaping the need for global cooperation when you face these kinds of global threats. All right, so I began researching this book in 2015, really researched 2015, 2016, wrote it in 2018, 2019, and I approached the book research the way I would a Supreme Court brief. We're talking scorched earth. I'm gonna get every single document of any kind. I interviewed everybody, Clinton administration officials, Bush administration officials, lawyers for the public interest groups, lawyers for the states, lawyers for the federal government, lawyers for industry. I interviewed judges, and yes, I interviewed justices. I also sought all their underlying documents. I ended up knowing far more than I think any of the participants knew, and they were surprised to find out things about the case, and they had worked on the case. Public record requests, but really voluntary. People gave me boxes and boxes and boxes of their materials, their notes, and of course these days they give me jump drives too. All right, so here are a few highlights for the book, just dancing through it a little bit, illustrative parts of the story. Chapter 1, of course, begins with the opening scene. It's October 1999. After a year delay, Joe, that's Joe Mendelson, walks from his Capitol office. He goes down to EPA. He hand delivers a petition. It demands the Clinton EPA, that's the Clinton EPA, regulate greenhouse gas emissions for motor vehicles. Joe, by October 1999, was fed up with the Clinton administration for the lack of any action to regulate greenhouse gas emissions. In 1992 and 3, he was hopeful. After all, the vice president was Al Gore, who wrote in June of 1992, Earth in the Balance. He said, this is an issue we can't compromise on politically. It's the biggest issue facing. He sat there year after year after year, and they didn't regulate any greenhouse gas emissions. So who is Joe Mendelson? He's a young public interest lawyer who worked for a public interest organization I can guarantee that almost no one, even at the Harvard Kennedy School, has heard of. And that's the Center for Technology Assessment. They had a total of 5 employees, a couple full-time, the rest part-time. They worked paycheck to paycheck and quite often for no paycheck at all. They had small offices on Capitol Hill. They were evicted from those offices, providing local zoning ordinances, not long before Joe was writing this petition. Joe worked very much alone. He worked on the petition late at night by his daughter's crib. None of the powerful national honor groups like NRDC, Sierra Club, Earth Justice, none supported him. And in fact, some of them at times actively opposed his efforts, opposed them. They even tried at one point to cut off his funding of his organization, and they didn't have much funding. But Joe refused to bend. He filed his petition demanding that EPA regulate greenhouse gas emissions. Joe's view was they weren't his bosses, the other groups. They could not tell him what to do. They had a lot of resources. He didn't have a lot of resources, but he didn't have their bureaucracy. He could decide on his own what he thought made sense. He drafted the petition in October 1998. He put it in a desk drawer. It took a year to decide to file, and there's so much pressure not to. And then finally, October 1999, he pulled the trigger. That's when he walked down to EPA, hand filed it, and sent a courtesy copy to Al Gore in the White House as well. Joe's petition made a pretty simple argument, but when it arrived at EPA, it was received by a docket clerk, Jamie Poole. Jamie Poole signed it, dated it, put it in a metal cart. I walked the pathway of the metal cart a couple of years ago, down to the EPA General Counsel's office. No one at the time Joe filed that petition, no one remotely imagined that 8 years later it arrived in the Supreme Court. The petition said, EPA, you have the authority and the obligation to regulate greenhouse gas emissions from new motor vehicles. They are air pollutants and they're endangering public health and welfare. You must do that under the Air Act. Now, at first, Joe actually had reason to think, after a little bit, the EPA might grant the petition. Not the Clinton administration, who when they received it, ignored it deliberately. They did not want to touch that issue, especially when Al Gore was trying to run for president. But once the Bush administration took office, in January of 2001, that's when he had good reason to think it might be granted. Why? Because of the Bush cabinet. Bush had named as EPA Minister Christine Todd Whitman, former governor of New Jersey, a person of enormous national stature, a moderate Republican, and a climate hawk, someone who took the job because she believed in addressing greenhouse gas emissions and regulating them. And that's the reason she did. I can do that from this position. Also in the cabinet was Secretary of State Colin Powell, also a climate hawk. Within a week of the administration taking office, he had a briefing in his office on climate change issue because he viewed it as a major national security threat, as did Condoleezza Rice, then the national security advisor. But no one was a bigger climate hawk than Paul O'Neill, Secretary of Treasury. Paul O'Neill felt so strongly about the climate issue that before the very first cabinet meeting of the Bush White House in January 2009, he went early to the White House, he went into the room where they were all going to meet, and he put in front of every cabinet member's chairs a copy of his speech he'd given a year or so earlier, comparing the threat of climate change to nuclear holocaust. All of them were dead set on regulating greenhouse gas emissions. And Christine Todd Whitman went off to Italy to tell the rest of the world that. But none of them anticipated they would very quickly and very suddenly be completely and utterly demolished in their efforts by this guy. Vice President Dick Cheney was close to the energy industry, and he came in and he kneecapped them. He came in and he got George Bush, who had pledged in his campaign to regulate greenhouse gas emissions. George Bush had made that pledge to regulate greenhouse gas emissions. Cheney got him to renege on that campaign promise within a few weeks, early February 2003, publicly in a letter to Congress, saying greenhouse gases are not air pollutants. We have no authority to regulate them. It'd be a bad idea to regulate them. And that was the end of the effort. But here's the thing. In sabotaging the efforts of Whitman, Powell, Rice, and O'Neill, Cheney and his allies, they made a misstep. They were not lawyers, and they stumbled on law. And they did not listen or consult with any of the career expert lawyers at EPA or Department of Justice. And the way they promoted EPA's denial of the petition, which EPA did, denied Joe's petition in September 2003, they made some mistakes. And those mistakes became their undoing several years later. Now, there was nothing easy or smooth, however, about the pathway of Joe's petition to the United States Supreme Court. But by the time Joe reached the courts, and the first court to hear the issue was the U.S. Court of Appeals of the D.C. Circuit in Washington, D.C. That's because under the Clean Air Act, these kinds of cases don't go to district court, trial court, they go right to the Federal Court of Appeals. And D.C. Circuit is exclusive jurisdiction over it. But now he was no longer alone. There are hundreds of lawyers on his side, for about a dozen states and more than 2,000 national environmental groups. And they called themselves the carbon dioxide warriors. But when they lost that first round in the courts in a sort of confusing, fragmented, split decision, but 2-1, when they lost in the DC Circuit, every one of those lawyers but one thought they should end the case. They said, all right, it's a bad opinion, but not much precedential damage. Wait and fight this another day in a different case. Let's not, too risky to go up. Only one attorney out of those hundreds thought further review should be taken. And that was Jim Milke from none other than the Commonwealth of Massachusetts. Jim Milke headed the Environmental Division of the Attorney General's office in Massachusetts. He had been there for years, Harvard undergrad, Harvard Law School, MIT, I think urban planning degree as well. And Jim Milke was the only one who said, I think we should roll the dice. I don't think we should acquiesce in this loss. Everyone else thought, terrible idea, you risk a major loss if you seek further review, don't do it. And there was enormous pressure put on Milke not to file. At one point, Francis Beinecke, a wonderful, very distinguished head of the Natural Resource Defense Council, called Milke's boss to lobby against Massachusetts filing anything more. And she called up Milke and said, the future of the environmental movement is on your head if you do those. Those are chilling words, but it didn't chill Jim Milke. Jim Milke knew they couldn't stop him. Any one of the parties could seek further review. So he said, we're going to file. And Riley backed him up. The Attorney General backed him up. At that point, once they were filing, everyone joined the petition. Because not that they wanted it filed, but they were not going to have him file and not be part of it. They wanted to control it, control what was being argued, and they actually thought there's no way it's being granted anyway. But they didn't want to look like they were fragmenting within it. The Supreme Court, to everyone's shock, I mean, shock, granted review. No one actually thought, they didn't want it to happen, but they never thought it would happen. Why? Because the last time the Supreme Court had granted review at the request of environmentalists over the federal government's opposition was 1971, 35 years earlier. The court doesn't do it. They grant requests at industry's request. They grant requests when EPA wants it on either side, but not over the federal government's opposition. But they grant it. The carbon dioxide warriors were like beside themselves. They couldn't believe it. There was going to be the first climate change case ever before the United States Supreme Court. And they reacted with expletives of different versions, some more secular than others. But Milke, when he happened, they're all celebrating. All the ones who didn't want the petition filed are celebrating. And Milke's celebrating, but thinking, what have we done? Because they could lose the case. If they lost the case, they could set back climate change efforts for a long time. It wasn't clear who had voted to grant the case, whether liberals or conservatives had voted to grant. You don't know who voted to grant. And so it sunk in on him, and he worried a great deal. Now I'm going to fast forward. Over the summer of 2006, the environmental groups filed fabulous briefs, fabulous written briefs championed by a wonderful legal academic who wrote just a very strong brief for all the petitions. But once that brief was filed in sort of, I think, early September 2006, then a fight which had been below the surface sort of erupted. And that was who was to do the oral argument in the Supreme Court. And I can tell you, I've been involved in a lot of Supreme Court cases. I advise people a lot of cases on the side. I did so a little bit in this case as well. And here's the easy part. Everyone agrees the best person on the team should argue the case. And everyone believes that person should make the best argument. That's easy. Now, there are about 100 lawyers on one side of the case here. And in the lower courts allow divided argument. You have 2, 3, sometimes 4, especially when there are many parties in the case. The Supreme Court doesn't. They want to hear from one, not multiple. So there's conflict, deciding who's going to do it. Sometimes it's a coin flip to decide who's going to do it. And the stakes and the emotions run high, as do the competing egos and ambitions. Standard operating procedure. But in this instance, the oral argument conflict was extraordinarily destructive. I've never seen one before then. I've seen a lot. It was incredibly intense. In fact, it was so intense that 14 years later, because it happened at the beginning of October of 2006, 14 years later, the principals involved are still not speaking. And they were good friends and colleagues. And then even after it was seemingly settled that Jim Milke, as the person who pushed the case, he had been the counsel of record all along in the Supreme Court, that Jim Milke would argue it. And he'd been preparing for 7 weeks in brutal preparation for the argument. The environmental groups who didn't want him, the states wanted Milke, the environmental groups had their own preferred advocate. The environmental group attempted no less than a coup d'etat days before the argument to replace Milke with a preferred attorney. They called them up on a Saturday morning, about a week and a couple days before the actual argument. And they said, you got to go. We've seen your practices. You're not competent. You're going to do a bad job. You're going to lose this big case. You have to step aside. Well, let me tell you, I've done cases. You don't do that. You can't bring in another person who's not been preparing a few days before the actual argument. That's a disaster to do it. You build the person you've got. You build up their self-confidence. You tell them and you help them prepare. You don't do this. But the fact that it was such a crazy idea underscores the level of distrust, the level of fragmentation within that team. Jim Milke was stunned destabilized, but he said, that's not going to happen. And it didn't. The next several chapters describe the oral argument in the case. And these chapters are designed to give readers a sense of, first of all, this is a stunning physical setting of the courtroom. If you get a chance, you should go. The extraordinary give and take between the justices and the advocates, but also, very importantly, between the justices themselves. What people don't realize is when the justices have an hour of oral argument in the case, and that's their standard, it is when they walk in that room for the argument, it is the first time the justices, the 9 justices, hear what their colleagues think about a case. By tradition, they don't talk about the case in the briefs until the oral argument. During that argument, they're spending an hour learning what each other thinks through the questions they ask. And they all know that. So they're all using their questions to try to lobby their colleagues on the bench. And the advocate, therefore, is given this incredible opportunity. They're there for that hour. They can hear what the justices are thinking. And they can participate in that. And you're only 74 inches away from the advocate. Between the bench where the justices sit and the advocate stands. It's really close. You're there, and the bench bows, so it's like they're around you as well. It's extraordinary notion of formality and intimacy. It's a great opportunity, but don't underestimate it. It's an unbelievable challenge too. What the advocate has to do is decide how to frame the issues in the case, stand up there and do the initial framing in a way most likely to win. It's all about framing. It can make a huge difference. You frame the case one way, and this is the way you should be thinking about justices, you can lose. You frame it another way, this way to think about it, you might win. You have to anticipate all the hard questions, develop crisp answers. These days, it's a hot bench. And the norm is the advocate is interrupted and has to answer questions 50 to 75 times in 30 minutes. Do the math. The questions take up some of your time. So you've got to be quick and fast and on point and be subject to mock and ridicule. No, it's not quite as bad as Tuesday night's debate, but they just jump all over you. You have no interrupted time. Now there's a little bit at the beginning, but not back then. You go and they're interrupting you and putting words in your mouth and mocking. If they're trying to convince the other justice, you have nothing to do with it. The justices, though, are much more polite than that, but it's demanding. They're not like our president. And trying to hit one of their questions directly is the equivalent of trying to hit a Major League Baseball pitch. The book describes the oral argument in detail. Milke's back and forth with Justice Scalia and Chief Justice Roberts in particular, how he had 23 questions from Justice Scalia alone during that argument. Here are our justices. This is how they sit, a quite attractive group. Here's the beginning of Jim Milke's argument in the Supreme Court. But I want you not just to read it, I want you to hear it. So I'm going to play the sound. And Joe, if you can give me a little thumbs up if you make sure they can hear it. Here we go.
Mr. Milke.
Yep.
Mr. Chief Justice, and may it please the court. If I may, I'd like to frame the merits very quickly and then turn immediately to standing. Although the case before you arises in an important policy area, it turns on ordinary principles of statutory interpretation and administrative law. EPA made a decision based on 2 grounds, both of which constitute plain errors of law reviewable under any standard. Not asking the court to pass judgment on the science of climate change or to order EPA to set emission standards. We simply want EPA to revisit the rulemaking petition based on permissible considerations.
All right, that's his beginning. That beginning, it's like 37, 38 words, whatever it is. That beginning was as carefully discussed, debated, planned out as the beginning of a Broadway production. There's nothing ad lib about it. How do I frame the case? In exact words. And imagine if you were a climate activist and you had, which many did, slept on the cold sidewalk in Washington, D.C. on November 28th before this argument. Because the next day was going to be the climate change case before the United States Supreme Court, the most important, compelling, existential issue to face the world and to face the Supreme Court, your Brown v. Board education. This is your chance for your champion to tell the court what an unbelievably important issue this is, what the Bush administration has flagrantly, unlawfully done, right? And instead, your champion stands up there and says, this is a question that arises as an important policy area, but it's really just a question of ordinary administrative law. Nothing special about it. And we're not asking you to pass judgment on the science of climate. You don't have to do that. You don't have to order, you don't order EPA to do anything. Just want EPA to visit the rulemaking petition based on permissible considerations, right? You'd be outraged. Like, what's our guy doing? He's throwing the case. He's not. He's making actually a fabulous legal argument to 9 justices. He's trying to win the case. He's not giving a speech, right, to a rally of climate activists. He's not running for office. He's not testifying before Congress. He is trying to get 5 votes. That's the rule of 5. 5 votes out of 9 from the United States Supreme Court. He has to speak their language. And it might make your heart, it does make my heart, go a-flutter to think about climate change. But it doesn't make the hearts of those 9 justices back then a-flutter. What makes their heart beat faster? Administrative law. So he's presenting the case to get their votes, not your vote, their votes. The best environmental lawyers are the best lawyers. And he's being a great lawyer here. And he said, how do I frame it? And the way to win this case is to make it about these principles of administrative law, traditional and order, nothing radical about it at all. I'm not asking for anything because he's not going to win that way. He is conservative court. He has to get 5 votes. He needs at least 1 conservative. So he's downplaying the ask, making it clear that we're not asking for much and we can do it without making any kind of radical notion of law. All right, take us to the conference. So 2 days after the argument, the justices meet in their private conference room. The conference room is behind the courtroom. You go behind the red curtains, across the hall, into the conference room. I took a walk along that as well. You walk in the conference room. When the justices are there talking about a case, no one's allowed in the room but the justices. No secretaries, no assistants, no law clerks, only the justices. And they sit in a way based on seniority. The Chief Justice has the most senior seat. That's a seat on the east side of the room. Justice John Paul Stevens, next senior. He sits on the opposite side, the west side of the room. And the other justices go in decreasing order of seniority. Scalia, Kennedy, Thomas, Souter, Ginsburg, Breyer, and Alito. Alito's a junior justice. That's why he's there. He's just been on the court. Actually, Roberts had just been on the court for a few months, but actually a year and a half. But he's chief, so he gets the senior seat. Alito, by contrast, has been on almost the same amount of time. He has to answer the door if anyone knocks. He's the junior justice. They go around the room, and what they do is they spend relatively little time talking about a case. Roberts goes first, summarizes the case in a few minutes, gives his vote before anyone else talks. Then Stevens gives his vote. No one else has talked. They go around and give their vote. There's not like a big discussion. No, they give their votes in order. They go around the room, and everyone wants to know really what one person's vote's going to be. And that's going to be Justice Kennedy. Because it's pretty clear from the case, and there are inklings in the argument, that this is going to be a closely divided case, and Justice Kennedy is going to be the decisive vote in the case. And that's what happens. Roberts says, affirm the lower court in favor of EPA. Stevens says, reverse. They go around, and then Kennedy says, reverse. And that means 5-4. But here's what most people don't realize. Once that vote happens, that decides really only one thing. And that is, who's the senior justice in the tentative majority? Those votes are not binding. Nothing is binding until someone writes an opinion which 5 justices agree to. And as soon as they're out of that conference room, the justices in dissent are trying to get the other justice to vote back with writing. Because at the end of the day, it's writing, not talking, which what the Supreme Court does. And so you have to write it and get the votes. And Kennedy has been known to switch votes. Stevens had to make a big decision as the senior justice of the majority. And that is, who does he give the opinion assignment to? He could give it au naturel to himself, right? Big case, great big case. And he's hardly in the senior justice majority very often because the conservatives take most of the cases, especially that term. Or he could do what people strategically do, is give it to the most marginal justice, the justice whose vote you're most worried about losing. And then you give it here to Kennedy. And I talked to Stevens about that. And Stevens said, that's the challenge. And he remembered how Brennan, in an early civil rights case, took the opinion for himself, a senior justice, and his decisive vote was Kennedy, and Kennedy abandoned him. And his majority became a dissenting opinion in a major blockbuster civil rights case. So Stevens was worried about that, but he finally decided, I'll take it myself. I'm going to do this one by myself. And then he had the job of keeping Kennedy and keeping his vote. So he put out draft number 1 of the opinion. 3 other justices joined him. The dissents are circulating their dissents. Scalia's got one, Roberts got another, and Stevens gets only 3 votes, so 4 total. He puts out draft number 2, 4 votes. 3, 4 votes. 4, 4 votes. 5, 4 votes. You know, what this happens is you try to get that person to join. You make compromise, qualifications, word changes, try to get them on. 5, 4 votes, 6, 4 votes, 7, 4 votes. At one point, compromise was made. Justice Souter, and no one knew this before, I didn't, Justice Souter drafted a separate concurring opinion. And Ruth Bader Ginsburg joined it because he didn't like some of the compromises we made. He didn't like that there wasn't tougher language to EPA about their responsibilities. Draft number 8, Kennedy signs. And Souter and Ginsburg withdraw that opinion, which is why no one ever knew it existed. And Stevens publishes his opinion, and he goes to town. He makes compromises needed, but he makes this a climate change case from the very first sentence. And that he didn't want Kennedy to write some narrow opinion, which wouldn't tout. He told me, this is an important issue to me. I'm a Republican. I'm very frustrated. Republicans are not taking the climate change issue seriously. So environmental groups in states sweep the table on the law. They win on everything, all 3 issues before the court, even one which they were fairly weak on. They win that one too. But Stevens writes this way, which is a call to action about climate change, has a major effect, not just on law, but on politics. It was though the Supreme Court is saying, this is a huge issue, EPA has to act on it. It's an amazing opinion that way. Although sometimes we try to outline it, a little complicated to read, what his reason is, but that's what happens. If you're trying to make compromise to get a vote, sometimes you have to avoid some things to get that 5th vote. But he was a Jedi master at this. The book then tells the story about how the case made history. It was a historic ruling, but it's the Obama administration which took this loss of the Bush administration, and as of January 2009, they ran with it. They'd hoped for legislation, they never got it. They took the loss of Massachusetts EPA and they built a massive amount of regulations based on that. They did it, and they took the promise of the case and they sought to realize it. And that's because the people in the White House, and that includes Barack Obama, it also includes Joe Aldi, who was also in the White House at that time, and my colleague, Jody Freeman, they knew one thing, and that is the United States could not solve the climate change problem alone. That the rest of the world would have to join. There had to be an international agreement. But every agreement had not happened, been frustrated, because the rest of the world understandably said, United States, you first. More of those cumulative greenhouse gas emissions in the atmosphere are from you than anybody else. China may do more per year at that point, but this stuff accumulates over time. It's your thing. And we're not going to curtail and promise the commitments unless you go first. And that's why every effort before then had failed. And Obama administration officials understood, and the president no less. He gave an incredible talk on January 26, 2009, 1 week after taking office. A call to action on the climate issue. Obama administration knew they had hopefully 2 terms, but just enough time maybe to convince the rest of the world by December 2015, when Paris new issue was going to happen, the U.S. was all in. And they did that through realizing the authority given to them and the mandate by Massachusetts EPA. New motor vehicles, of course, first, landfills, methane production, and of course the Clean Power Plan, which comes out for power plants in October 2015. They're pushing it out to get there before Paris. And it works. We have the first international historic agreement on climate change, December 2015. Now, when I started writing this book and researching in December 2015, I knew the story's ending, right? It was a pretty, great story. The trajectory was obvious. You start with Joe, back in actually 89, the book begins or so. You end up with Paris in 2015. And then I know you guys at the Kennedy School are a lot smarter on these things than the folks like me over the law school. In December 2015, I did not anticipate one thing. I'm sure you guys did. You saw it coming. But I did not anticipate by the time my book would be done that Donald Trump would be president of the United States. And so that was my unanticipated challenge I mentioned at the beginning. And that is what to do with it. What to do with this book with Donald Trump. And here are the three things I knew. One, I knew I had to explain it, right? I had to explain how it fit in the story. I had to explain its relevance, especially its historic relevance. But I also knew something else. I did not want this book to become yet another Trump book. I did not want this book to be wed to the latest event of the moment. I was trying to tell a book with a long half-life, to tell a story about people, about law, about courts, about an important issue that would be sort of sing to readers for a long time. What people could do, long past the presidency of Donald Trump. I want readers years from now to be able to enjoy and learn from the thrilling story told and be inspired by it. And perhaps even say now, if I can have the book's life be long enough to have some reader years from now pick it up, read the book, come to the epilogue and say, now, who is that guy, Donald Trump, that's mentioned there in the epilogue? But that's the role. The role of the epilogue is to place Donald Trump in perspective, what lessons the book story has for us all. Lessons like, right, the difference one person can make. Here we had many different one persons. We had Joe Mendelson. We had Jim Milke. We had judges. We had justices. People who stepped up to the plate against all odds. They made a difference. And also to underscore the fact that it's not the votes of 5 justices that can achieve long-standing transformative change that the country may need. Brown v. Board of Education was an amazing decision. None is more important than that. It did not get rid of racism in the United States. It was important, a catalyst for all kinds of laws, unbelievably valuable. But at the end of the day, on issues like this, whether it's racism or whether it's climate change, it takes ultimately the votes of more than 5 justices. It takes the votes of people in elections. That's how we make transformative change in the United States. Supreme Court decisions can catalyze, push, cajole. They can leapfrog us. But we do it through elections. That's our system. It's not courts. It's elections. And that's why the timing of this book, and actually might talk to all of you, and why I'm particularly delighted to be at the Kennedy School, is so important. In case you don't know, there is an election coming up. It's in just a little more than a month from now. It's a very, very important election. A lot is at stake. And on that one, it's not going to be the votes of the 5 justices or 9 justices or currently 8 justices. Many of them who don't vote actually in elections because they think they shouldn't vote elections. It's your vote and the votes of people in the community. That's what's going to determine whether Massachusetts EPA realizes its real promise. Thanks very much. Absolutely delighted to be joining you and to see Joe. And I'll stop my share screen too.
Okay, thank you, Richard. That was fantastic. I want to remind everybody who is joining us here to use the Q&A tab at the bottom of the screen. You can type in your questions there and I will relay them to Richard. As the questions come in, I want to reflect a little bit on this. Richard and I haven't talked about this, but you know, it wasn't just that I joined the team under President Obama and we actually took this and started working quickly on implementing what had come out of Mass v. EPA. I was a junior staffer at the Council of Economic Advisors in 1999, working on, among other things, climate change policy. I was doing a lot on, I did a lot in 1997 on Kyoto, and then sort of post-Kyoto, how could we get more countries involved? Because that was the big political barrier we were facing in our domestic politics. And it was a surprise when we heard about the testimony that Richard writes about, that then EPA Administrator Carol Browner made up on Capitol Hill, saying, sure, we've got the legal authority to regulate greenhouse gases. And so it's one of those things where I remember, and he writes a little bit about this early in the book, about how the White House was a bit surprised by that. We were, but it does say something about how much things have changed. About in 1999 with the then leading candidate and eventually the nominee of the Democratic Party, thought of as probably the most adamant advocate for climate change policy and taking action on climate change, and Al Gore not really wanting to embrace that issue much. We fast forward to 2008. We actually had both presidential candidates being pretty ambitious on this. When we came in, I remember working on the presidential transition team for President-elect Obama at the end of 08 and early 09. The environmental community wanted us to do the endangerment finding on day one. You know, it's like, you've got to do this on day one. And we had to say on day one, two things happen. The president takes an oath and we party. And there's no, there's no work really being done that day other than that. But we also emphasize the importance that we do this right. And I think it gets to when we think about the law, and it's a compelling story. I've really enjoyed reading this. Let me make sure it shows up on the screen here. But you want to make sure you do it right. And there's some of this, you know, as Richard said earlier, there was these early missteps in the Bush administration that set the stage really for the success by the challengers. In the end, in Mass v. EPA, you know, in Obama, it was clear, we're going to do the Endangerment Fund, which is one of the, it's like the first thing you have to do as a condition for then regulating the greenhouse gases. And we're going to make sure it's ironclad. And it says something that even in a Trump administration, where they've had some of the advocates on the other side saying, we want to undo the endangerment finding, they haven't tried. And I think it's a testament to the staff, the scientists, the experts, and the lawyers at EPA for when they did the endangerment finding, because they were able to take what came out of Mass v. EPA and then build this really solid foundation for how we move forward. I do want to ask a question about that, though, in a moment, about how we might think going forward. The one question I had, because it's a question I always had about this that I didn't know until I read this book, which is why Section 202? Okay. You know, why motor vehicles? Why not power plants? Because back in the 90s, we were thinking more about power plants, to be honest, at least within the Clinton White House. So I'd love to hear this, because it says something about, part of it I think is chance, but part of it also says about how we think about the role of the Clean Air Act that gives the public the opportunity to use the legal system to try to petition for action.
I can answer your question.
Great.
I asked that question. There were, when the Bush administration is there, and actually during the Clinton administration, there was a lot of debate which way to go, and different groups went different ways. Some people brought common law nuisance lawsuits against the government, saying, or against the industry, saying you should regulate under the common law of nuisance what you're doing. Others looked at different provisions of the Clean Air Act. Some went after national ambient air quality standards under Section 107. Mm-hmm. Some targeted sort of the stationary sources. Joe was the one who targeted motor vehicles. And that was because the Center for Technology Assessment was interested in technological innovation, and they were interested in cars. So cars was what was the thing they cared about. Right. They didn't think about power plants. They thought about cars and motor vehicles. And so Joe's the first one out. He's the first one who really files a petition. It ends up being the one that becomes the vehicle. It's the one that gets denied by the Bush administration and then leads to the first lawsuit. And there are other cases that were sort of out there in the periphery, hanging out, but they didn't move. Mm-hmm. and so they stood by the wayside. It was serendipity, personal interest,
Right.
but it was really that they were a car group. They weren't a power plant group. Because you can imagine, power plants, like what a great target. The other thing I want to mention that you said a moment ago, because it meant a lot to me, was that the Obama administration got that proposed endangerment draft out, I think on April 2nd of 2009. That is like speed of light.
Yeah. Yeah.
But the reason they could do it, and this is where they did it right, and the Bush administration did, is they worked with the career people. The Obama administration, they didn't have all the science and the studies,
Right.
but the EPA, those EPA scientists during the Bush administration and the economists, they were working. They were studying, they were working. They had done all the studies of endangerment, whether it was there or not. That's what they do. And the Bush administration hadn't actually stopped them from working. And that's one thing different than the Trump group, which actually tries to sort of stop the career people from actually doing their jobs. The Bush administration said no regulation, but the EPA scientists, the economists, they were doing their work. So when the Obama people come in and they're willing to talk to them and defer to them and respect them, they're like, here it is. And then the hard work has to be done to actually draft and write the information, but you could do it by April 2nd. But it's not like the Obama people were working from scratch in January 2009. They knew how to work with career people and respect them. And that, of course, has been one of the big failings of the Trump administration. And that's why they keep losing case after case after case in the courts, because they're sloppy, impulsive, and they don't listen to their expert lawyers. And career people, they'll work for you. If the democracy says this is elected, they'll work with that president. They'll work with that head of EPA. They're not going to be irresponsible, not no professional loss of integrity, but they'll work with you. But this group doesn't work with them.
Right.
And so they lose.
So when we look back to 2009, we had this process with the endangerment finding. The Obama administration went forward on regulatory efforts through both EPA, and they worked with the Department of Transportation on the so-called car rule to reduce CO2 emissions from the tailpipes of vehicles. Of course, at the same time, the Obama administration is working with Congress on new legislation. WaxmanMarquis passed the House of Representatives that would have created an economy-wide cap and trade program. And of course, as we all know, it failed in the Senate over the course of the rest of 2009 and 2010. So Richard, let me ask you, this is from one of our colleagues, Professor Stavens. When you look back at this and you think about, suppose in a counterfactual, WaxmanMarquis had become law, would we have thought of the Supreme Court case? Would we have thought of the regulatory actions by the Obama administration differently if we had instead been now in I think it would have been year 8 or year 9 of implementation of WaxmanMarquis had it become law?
Yes, absolutely. The case would not have, as a practical matter, had the significance it had. It would have been used, this would have been the story. People at the beginning of the Obama administration, they used the fact of mass versus EPA as leverage to try to convince Congress to let's have some legislation which really looks at this issue, does a national cap and trade program, does trade emission allowances. Let's not force us to rely on this language written in 1970 and to try to jerry-rig it to get something really interesting and innovative, like the Clean Power Plan and the rest. But that's not, no one thinks that's the best way to do it. So it was like, if you don't give us something which is sensible and which has trade-offs, let's have marketable allowances, which also allow for payments which can be used to help communities that are hurt by this transition to a different kind of electricity grid. Let's help the communities in West Virginia and the rest. You can put together a really wonderful program by legislation. And EPA is much more circumscribed what they can do with an old statute and try to make it work. They did amazing things, but what would have happened if we got the legislation? Is Masters EPA's significance would have been as leverage to create what was really needed, which was national legislation with cap and trade right in the middle.
As one of the staff working for President Obama, I had a lot of meetings with congressional staff. We did use that line quite often to say we can do this under the Clean Air Act, but this approach is more comprehensive. It can be better designed. The point you made, I recall having a meeting probably late summer or so of 2010 with some Senate staff, Democratic Senate staff. And they said, you know, it'd be really good if we waited another 2 years. I know you're saying that, but, you know, let's see. And I said, you know, we've been working with you now for almost 2 years to try to get legislation. And we said, if we don't get legislation, we're going to go down the regulatory route. So don't just ask for another 2-year delay. Now, what's interesting about this, and it gets to how we think about the politics. It echoes a little bit the politics going back to the late 90s. You know, in the end, it's clear with the election of a Republican House of Representatives in November of 2010, there's not going to be legislation in 2011 or 2012. But it wasn't really until the summer of 2013 that President Obama really takes that next step to go beyond just what we can do regulating in motor vehicles, right. Announces the climate change plan that then charges EPA to move forward, that then culminates with the Clean Power Plan and methane
right.
regulations, et cetera. You can see that, well, at least for President Obama, he knew he'd run his last election.
Right. Now, look, I only have a lot of time, but I've got to
please.
Okay. A couple things. One is what people also forget was in June, right? When the WaxmanMarquis stuff is happening, which is June of
2009 is when they voted it in the House.
They voted out. At that point, by June of 2009, the Democrats have majority of the House of about 60 to 80 votes. By June of 2009, they have 60 senators who are Democrat or aligned with the Democratic Party. They have a supermajority in both chambers, and they can't get it passed. And the reason they can't get it passed is Democratic senators. Democratic senators who are worried about the risk of voting for climate because it might be politically unpopular. Why does Barack Obama kind of retreat a little bit in 2011, 2012? I've done a word search for Obama. He said the words climate change and global warming about 80 times in 2009, about 80 times in 2010. After they lost the House, someone must have said to him, don't say those words ever again. He did not start uttering the words climate change and global warming until he wins re-election in 2012. And then they run with it. It is complicated, a hard political issue for a lot of people. And it's not just for Republicans. The Democrats have found it to be hard too. Maybe that has changed now. We may have had a sea change in the country. And that'll be very important for the next president.
Let me ask one final question here. Of course, under Trump, we've seen a lot of conservative judges at lower level courts having filled 2, and we're now waiting to see about a 3rd seat in the Supreme Court. What does this mean when we think about sort of the future of climate change policy and regulation, both the odds that a case moves from lower courts that are now being decided by more conservative judges that may not be as enthusiastic about a mass EPA ruling, as well as what might be the future in which a Supreme Court might try to reverse mass VEPA. We'd like to hear your thoughts on this.
They won't reverse mass versus EPA.
Okay.
Because mass versus EPA, greenhouse gases are air pollutants under the Clean Act. Supreme Court does not overturn prior cases statutory interpretation. They do constitutional law and statutory interpretation. I can find you some counterexamples, but they're very distinguishable from this case. Here's the problem, though. If the next administration, so it's the Biden administration, has to try to do all the kind of creative things that need to be done to address this problem with the old language, there's going to be tension between that language and what needs to be done. And skeptical judges and justices may find that the regulations being done are beyond the statutory language. That's the risk here. That's why if there's a new administration, they need a new statute. You actually need Congress to pass something. They haven't revised the Clean Air Act since 1990. That's 30 years ago, before a lot of your students were born. They haven't. So we need a new statute, a new thing, climate change, but it still can be done. A lot can be done with the existing Clean Air Act, but doing all the more ambitious things, we'll fight like crazy in the courts to say it's lawful, and I worry about more conservative judges and justices, but not if we get new legislation, because those judges and justices, they'll follow the legislation. We get in the language, we'll win.
Great. So I know Richard has to run a class. It's a couple of minutes before 1. One last thing before we wrap up, I want to remind everyone that the seminar will meet again in 3 weeks on October 22nd. A related seminar, we're going to have Cheryl LaFleur, the former chair of the Federal Energy Regulatory Commission, She will be speaking on challenges to successful decarbonization in the United States and strategies to overcome them. And finally, Professor Lazarus, it is a pleasure and an honor to be able to share this hour with you. Thank you so much for joining us. Thank you for writing, like what I said, it is a compelling story. And I really encourage everyone, even if you're like, oh, the law can get kind of technical and you get into some of the details.
No.
It's not this story. This is a great story about the challenges of how we as a society, how we in our government, across all the different branches, how we might try to work together and deal with all the different kinds of big picture politics and little picture politics come together to actually tackle the challenge of climate change. It is really a great read. I'm thrilled that the book is out. I'm thrilled that you're able to sort of share this story and share the insights from all of your work on this, Richard. So again, thank you for joining us and look forward to seeing you again, hopefully soon in person, so we can continue conversations about the future of climate policy.
Thanks, Joe. My next book, the Joe in the first chapter will be Joe Aldi.
I look forward to that.
All right, take care.
Richard. Take care. Bye-bye.